everyone for coming. This is a great turnout. Today we have a really great presentation. Dr. James Binnall is here to talk a little bit about jury selection for felons and kind of the role in the system for felons. I think it's a great big issue, right? So we think a lot about the political system and in a nation that has such a high level of criminalization and incarceration, what happens to people either once they're in prison or once they're released from prison in the political process. We think a lot about that issue with disenfranchisement and the right to vote. Right? I think nationally there are huge restrictions in many states on the right to vote for people who are released from prison. And that applies to a large percentage of African American males, young males in the country. We don't often think about jury selection and jury service and the exclusion of felons from jury service. But it's another huge issue. You think about kind of for the founders, the jury played a really important role in our nation. The right to a jury trial was in every single state constitution, so it's a right that the founders used as really important. And this idea of having a representative jury, a jury from your peers in the community, was one of the kind of bedrock principles for the nation. So I think this is an issue that really deserves a lot of attention. So Dr. Binnall is here to talk about that. He's an assistant professor at Cal State Long Beach, has a JD from Thomas Jefferson in San Diego, a master's degree from Georgetown, and a doctorate degree from UC Irvine. He's going to talk a little bit about kind of the national implications and trend in jury service for felons, but also what we're doing here in Maine and how we're unique. So thank you.
Good afternoon. Thank you. Two sort of specific thank yous. First is to Professor Burke, Jim. This whole project started a few years back when I shot him an email and said, hey, would you want to help out? I'm from Boston, so I know Maine. I'm not that kooky California guy that you might think I am when you see the email address, so what do you say? Can I come and hang out and do some interviews and maybe help me find our participants? He said yes, and so I guess it was, 5 years ago at this point we started messing around with this stuff. And Julia for, where'd you go? Oh, there she is. Julia for letting me come and talk to you and bore you over Chinese food. So, generally what I want to talk about today is the exclusion of convicted felons from jury service. More specifically, what I want to talk about is the work that I did in Maine. Maine is a very unique place with respect to the statutory restrictions of felons from jury service in that there is no restriction. Every other state, the federal government, and DC all have some sort of restriction on the convicted felon's opportunity to serve. So what I'm going to do today, and these studies were qualitative, so it takes a little bit of time, so I'm going to move kind of quickly through the background, and I apologize for that in advance, but if you have questions after, I'm happy to answer them. I'll go through some of the background, and then I'm going to talk about these twin Maine studies that I did. Briefly on the methods, what I found, and then some larger conclusions. So first, and I'm going to walk out here, I apologize. So felon jury exclusion jurisdictionally, there are lifetime bans. So if you have a felony conviction in 27 states and in the federal system, you are permanently excluded from jury service. In 13 states, you are only excluded during your sentence. So probation, parole, felony probation, felony parole, you are not allowed to serve. When that expires, you are then back on the jury rolls, then you can serve. 2 states allow for lifetime challenges for cause. These challenges for cause they do not need to be supported by any other factor. The simple fact that you're a felon, you are automatically removed for cause, excluded in 2 Midwestern states. You'll see I have a little map coming up. And then there are hybrid restrictions in 7 states and in Washington, D.C. I'll give you an example of a hybrid restriction. Washington, D.C., once your sentence is complete, there's a 10-year waiting period until you're then allowed to serve on the jury rolls again. I did some work in D.C., spoke to some judges, some of the district judges there. They want to change that policy. That's one of the more severe hybrid restrictions, but as it stands now, it is a 10-year waiting period. This is what it looks like nationally. And as you can see, the no exclusion, just you guys up there in the corner. Your statutes do not mention the exclusion of convicted felons from jury service at all. Now, I've gotten in sort of a huff with a couple folks from Colorado because they say, well, no, on petty juries, convicted felons can serve in Colorado, and that is true, but it's a hybrid restriction. So they can serve on petty juries, but on grand juries, they are permanently excluded from it. So it is, in a sense, a hybrid restriction. The structure of these statutes. So they are categorical. Where they are imposed, they're categorical. They apply to all convicted felons, and they apply in both sides of litigation, so civil and criminal. There are exceptions to that. Arizona makes an exception for first-time offenders, Nevada, violent offenders, non-violent, Colorado, as I said, petty grand juries, and in Oregon, they differentiate between civil cases and criminal cases, which actually, when you see the rationales for these exclusions, probably makes the most sense. Oregon probably does it. So if you buy the restriction, if the justifications at all, Oregon does it probably the best way as far as the exceptions go. What are the justifications? Well, when you look at the case law and you look at the legislative history of these statutes, the justifications seem to be twofold, practical justifications. Now, there's a philosophical justification that, look, you broke the law, you simply don't deserve to be part of our jury system. You get it. Hard to test. These are more practical justifications. These are what justices cite in opinions dealing with felon jury exclusion. They are the first is inherent bias. They suggest that if a convicted felon were allowed to serve, he or she would hang every jury they're on in a criminal case. Courts have held that this makes little sense on the civil side, but still operates as a justification to exclude from the civil side. So the mechanism there is a little unclear. The character rationale, the mechanism is really unclear. Some courts suggest that it's the appearance of a tainted deliberation process. Some courts suggest that it's simply that a convicted felon lacks the requisite character that we ask our responsible jurors to have. How a lack of character, however defined, equates to a bad juror doesn't really explain to me or anybody, but still it's cited all the time as the primary justification for the exclusion of felons from jury service. So what assumptions do we make, arguably, if we buy those justifications? I suggest that the first assumption we make is some level of homogeneity among convicted felons. These are categorical restrictions. So it isn't they apply to you and not you, and we're going to look at your case individually. It is, if you have a felony conviction, you are excluded. What that suggests is some sort of homogeneity, that felons are all alike in one way or another, depending on what justification you sort of hang your hat on. Not only is there homogeneity, but it's homogeneity in the realm of the belief is that convicted felons are somehow fundamentally flawed, right? That either as a group lack character or as a group are inherently biased and more willing to acquit than you would be to convict. And finally, that the biases, the character flaws, are very different from quote-unquote non-felons. That there are this group of people that are fundamentally distinct from people without a felony conviction. Now again, I raise these points and I've done some studies on some of this stuff. Just something to think about when you think, now, and Eugene mentioned something I want to just touch on. Look, there's over 2.2 million folks at this point incarcerated in the United States. Over 90% of them will be released at some point. A lot of collateral sanctioned discretionary disabilities, which I'm sure you've all heard about, right, with housing and voting and other sort of public assistance, they operate in this categorical way. So these assumptions aren't unique to felon-juror exclusion. Whatever the justification is for, arguably, let's say, low-income housing, right, federal housing, the restriction on that, it makes assumptions about this population, right? So again, this isn't unique to felon-juror exclusion. I'm sorry I'm speaking really fast, but I want to get some of the quotes. That's sort of the fun part of this. Prior research. All right, I just want to take a minute here on this slide, and this isn't because I'm so wonderful. It's just that there hasn't been any research on this, empirically. It really isn't. I don't even make my students read my articles, so it's not, I'm not that way. Look, legal research. Let's start with that. The seminal article on this was written by Professor Brian Colt at Michigan State Law School. 2003, it's two things sort of spawned my interest in this. Right? The first was that article that I read just prior to starting law school. And the second is that I am a former offender. I spent over 4 years in prison for a DUI homicide. Had a wreck in 1999, my best friend got killed. I got out, took my LSATs inside, got out and went to law school. Finished law school, got barred in California, first shot, both times, moral character and the bar. And then got called for jury duty and was told that I could leave and would never be called again. and the week before had tried a case in the very same courthouse that had just kicked me out for jury service. So I said to the person who was sort of the jury clerk, I said, you know, that doesn't make any sense. I'm an attorney. I came in a little special entrance. And she said, write your congressman. So I wrote an article instead. And the article compared jurisdictions where you could become a lawyer, but you would never be able to serve on a jury again. And in fact, there's 28 of them. So that's sort of how my interest in this came about. Now, on the legal side, these felon-juror exclusion statutes have been challenged two ways: equal protection claims and fair cross-section claims. Neither have ever been successful. Equal protection because we don't offer any special protections class-wise to those convicted of a felony. And cross-section claims have failed because, again, we will not categorize convicted felons as a distinct group for the purpose of a fair cross-section claim. Some of us have argued sort of a rational basis with Veit or irrebuttable presumption doctrine might be the way to go there, but no one's sort of receptive to that. So at this point, those are the two challenges that have been levied. They both failed. Empirically, the work on felon-juror exclusion started with Darren Willock in 2012, where he looked at felon-juror exclusion statute, or the felon-juror exclusion statute, a permanent restriction in Georgia, and found that that restriction racially homogenized juries in Georgia. That it limited the number of African American men on juries, average in a number of counties, from 3 to 1, which is very important on death penalty cases because of what we know about jury science and having there be sort of groups sitting on juries and the effect that you have when you have more than one racial minority or gender or socioeconomic background. So he found that in 2012. Until 2014, when I did my first study on felon-juror exclusion, it was sort of ignored, right? Voting is the sexy civic disenfranchisement, right? Jury exclusion, the argument I used to get when I started this work was, well, no one wants to sit on a jury, so who cares what you're doing? You're off in a corner and no one cares, which you'll find in Maine was not really the case. So in 2014, I conducted the first study on felon-juror exclusion, and I compared three groups of folks: law students in Southern California, law students, regular old eligible jurors not enrolled in law school, and convicted felons, 200 in each group. Ran some regressions on them, pulled some demographics, and what we found was that in terms of their pretrial biases, we tested them on a pretrial bias scale, a number of scales, we found that convicted felons and law students, that there was no statistically significant difference in the amount of pro-defense, anti-prosecution pretrial bias. So what does that suggest? Either you let convicted felons serve, or all of you get excluded from jury service, also based on your inherent bias to favor the defense or to be critical of the prosecution. 2017 article that just came out was the first article I did in Maine, and that was a number of interviews, 30 some odd interviews with former and prospective jurors here in the state of Maine who were former offenders. And what I wanted to get at with that study, what I'll talk about today, is what does it mean to people who have been convicted to be shut out of this process, or in Maine, conversely, to be included in that process? How does it play when we talk about criminal desistance mechanisms and successful or failed reentry? The second part of what I'm going to present today is the second main study I did, where I talked to courtroom personnel defined as trial judges, defense attorneys, and prosecutors, their take on your policy. I say your, assuming everyone here is from Maine and will practice in Maine. Your policy of including, I call it Maine's felon-juror inclusion statute, or lack of statute. And then the final article that comes out this year that I've done is speaks to the second justification, which is the character justification, and it was a mock jury experiment where we put convicted felons and non-felons in the same room. We showed them a trial stimulus tape. We did 25 juries. NSF funded it. Great study. And what turned out was, in fact, the taint of the deliberation process actually wasn't there. In a lot of respects, convicted felons actually enhanced the deliberation process by bringing diverse perspectives, diverse backgrounds to that process. Respectfulness, we coded for a lot of sort of interpersonal variables. They were conscientious, thorough, thoughtful jurors overall when you look at that data. How does it work in Maine? So I have a little history for you. Your library here helps you all with the sort of public libraries. So from 1652 until the Acts and Resolves of Massachusetts, English common law governed juror eligibility here. Under English common law, only free and lawful men were eligible to take part in the jury process. That exclusion continued with the Acts and Resolves. Chapter 29 of the Acts and Resolves states, if any person whose name shall be put into either jury selection box shall be convicted of any scandalous crime or guilty of any gross immorality, his name shall be withdrawn from the box by the selectmen of his town. So early in your history, you prohibited convicted felons from serving on juries. In 1820, when Maine achieved statehood, you continued to track Massachusetts' policy of mandatorily excluding convicted felons from jury service. In 1954, though, Maine's policy regarding felonious jurors underwent its first substantive revision, moving from a mandatory exclusion to a permissive exclusion. That year, Maine added a juror exclusion and exemption list to its code. The exclusion exemption list did not include convicted felons. It stated, the jury commissioners may also drop from the list names of persons who have been convicted of any scandalous crime or gross immorality. The permissive disqualification lasted until 1964, when Maine again altered its criteria. In 1964, Maine dropped the permissive disqualification language from its revised statutes and included an exemption exclusion list that again did not include convicted felons. So in 1964, Maine did not restrict the convicted felon's opportunity to serve. 7 years later, 1971, a convicted felon's right to sit on a jury was tied to the right to vote, which up here was ineffectual because convicted felons weren't denied the right. So the provision read, a prospective juror is disqualified to serve on a jury if he or she has lost the right to vote. It didn't change convicted felon's status, though, because Maine has never curtailed the right to vote. The present statute governing juror eligibility in Maine makes no mention of convicted felons. Present statute that has been in effect since 1981. So you have allowed convicted felons to serve really since 1964, and Maine is now the only jurisdiction that places no restriction on those with serious criminal records. Now, these are the twin studies that I conducted in Maine. Study one, they're both inductive, meaning I went into these with no preconceived notions about how convicted felons would talk to me about jury service. I had no preconceived notions about how courtroom personnel would talk to me about the inclusion of convicted felons. I interviewed juror-eligible former offenders for study one, and I interviewed courtroom personnel, as I said, prosecutors, defense attorneys, and trial court judges for study two. In study one, we had 32 participants. We had 7 former jurors. We had 6 who were summoned, no serve, and we had 19 eligible jurors. So subject to a juror summons. I conducted in-depth semi-structured interviews with all these participants. 27 were in person, 5 telephonic, and each interview lasted 30 to 96 minutes, fully transcribed, thematically coded. So what did I find? Well, interesting, 4 themes arose from this research. The first was that the convicted felons that I interviewed wanted to be the ideal juror. They had a really specific idea of what it meant to be an ideal juror, and they wanted to live up to that. So this is the sort of fun part. This is where I'm going to tell you what they told me. With respect to theme 1, I had a prospective juror, someone who had never been called, tell me this, with an extensive criminal record. If you're a juror and you're to do the job of a juror in the state of Maine, you have to prove without a reasonable doubt that the person's guilty or not guilty. So the facts don't back up what's being, brought up against them, then no, they shouldn't go to jail. But I mean, if everything's in black and white and they're guilty, then obviously I would find them guilty. I've done a lot of jury work, and that is a pretty concise statement about what it is what job it is of the juror when they're placed in the deliberation room. Another convicted felon, someone who had served as a juror, said this: I just said you got to go from what you really see, because there were like 2 ladies that had never been on a jury, and they were like, we're not going to make any decisions. And I said, you have to go with what you see, the evidence. Everything that you get that we've already been through, you have to weigh that out. You can't just say yes or no based on nothing. I even got up and put all this stuff on the chalkboard, the pros and cons. I mean, that was a fascinating quote to hear someone say that who had been in and out of the system for for about 15 years. A final quote with respect to this ideal juror role. This is, again, someone who had been called but dismissed for other reasons, and not based on his felony conviction, said, "I don't think knowing I've done jail time and had the experience that I've had behind bars would impact how I would answer to somebody else in the same situation. I've been out. I've been away from it for so long, and I've been off probation for 4 years now. It's just part of my life that I went through, and I've grown up, and I've separated myself from it. So it's not so fresh. So I wouldn't feel bad if that's the consequence and they were guilty, that's what I would have to do to convict them." So as you see, the folks that I talked to up here seem to have a pretty good idea of what their role in the jury process is, right? One convicted felon also said, "But I sat right there and everything was pretty clear." And then the way the law is and read, it was like he blew it. And I figured, and this is the interesting part of this quote, and I found this fascinating. Most of the folks that I interviewed found that, or felt that the state had given them an opportunity and had placed trust in them. And they felt bad not living up to that ideal role. They felt bad not doing their job. He said, "I figured, the state, gave me the trust enough to sit on this jury and do what had to be done, whether it was guilty or not guilty. So if it was guilty, I was forced to prove guilty." A second theme that arose here was this idea of the felon label. And you've all heard of sort of labeling theory, I assume, and the idea of the looking glass, right? So we are reflected appraisals, right? We are what others think of us. Well, in this study, that reflected appraisal existed for bad and for good. So on the bad side, I had folks tell me, here's a 26-year-old man who pled guilty to a B&E, said he underestimated the significance of a felony conviction. Said he didn't think the felon label was this bad and was unaware of the consequences when he said okay to taking the deal. Another woman said, "It really sucks because I feel that people look at you differently just because I have a felony, just because I did time in prison. They look at me like I'm a bad person. And when they look at somebody that has a felony, they try to steer away from them. They don't want anything to do with them." Well, not only did this reflected appraisal come through on the negative side, and with their negative experiences with reintegration, it also came through on the positive side. Here's how. One felon said, or I hate to say that, but one sort of former offender said, "Jury service was kind of weird. I was always facing the judge. And doing jury duty, you're kind of working with the judge and the lawyers. And they're not, getting ready to send your ass to jail." Another said, "It was like I never had any problems. I was the same as everybody else in the room. Even one of the courtroom marshals who was in there when I got sentenced, he knew who I was. He was like, 'I remember you,' and then he got me coffee. So that was pretty cool. I felt like the score had been, evened out." Another participant said, "I felt like I wasn't trying to get away with anything. It just felt like I was not judged by somebody because I was there the whole time. Everybody, all the guards treated me with respect like anybody else. They fed us. It was just like a normal day and a normal thing." So what folks thought of these former offenders mattered, negatively and positively. Most importantly, and sort of other studies of criminal desistance sort of back this theory up, is the idea that, look, when these reflected appraisals from family and close friends, they mean something. But when they mean the most is when it's from an official institution, especially the institution that actually was the institution that affixed the label in the first place. And so for a lot of these participants, the state, the one who had sort of branded them a felon, they did it themselves, arguably, we can get into that conversation. But the idea is someone affixed the label, right? Someone gave them that official title. That same entity is now saying, "We welcome you back. We trust you with a very important decision regarding someone else's life," and they felt that. And what came about was that they saw themselves as worthy. They found self-worth. Another participant said, "We need you. We need your help to make some of the right decisions." He said that's how it felt to him. And it's kind of cool. They said, "We're going to hand you this responsibility. Do what you need to do with it." When you're not used to being given responsibility and always being left out because, oh, screw that guy, he's got a record. We don't need his help. We'll find somebody who obeys laws and makes all the right decisions. So now it's like, wow, they're going to give me this responsibility, and try to get me to make the right decision. So I feel like I should make it. When I asked about this specific self-worth, this is what I heard. I think it's very valuable because you also see, and this was them explaining why someone with a felony conviction is in fact a better juror than someone who had never been through the system. It's a very valuable because you see the other side of things. If you've never been there and you don't really see that side, but if you've already been there, you can see both sides equally rather than favoring one side or another. I think it almost makes you a fairer jury than, somebody who doesn't know the experiences from the other side. Another quote reads, "We've had different life experiences, so we're trained without having official training. To look at things differently, to not just take things at face value. We're able to read between the lines. It's more like having street knowledge than book knowledge. There's a difference there, and that difference is valuable." The last one, only because I love it, says this, "Former offenders have seen both sides." You know what I mean? You can't bullshit a bullshitter. You know what I mean? Like, I've been there, I've done that. You can tell me if someone's trying to bullshit you or someone, you know the lies because you've said the lies and you've lived that life. So they turn, and this is a common thing, right? When you read about desistance, criminal desistance, and successful reintegration, Shad Maruna wrote a great book about this called Making Good. When you read about criminal desistance, one of the ideas is that for anyone to successfully reintegrate and to leave a criminal past in the past, they must construct a coherent desistance narrative. That desistance narrative, a personal narrative, you have to be able to rectify a criminal past and a current law-abiding present and then future. Well, how do you do that when there are permanent exclusions constantly reminding you of the person that you used to be and the mistakes that you once made? Here, what we see, so one of the techniques many former offenders use is sort of this wounded helper principle, right? That they see value in the experiences they've had, even very negative experiences. And they weave that into that desistance narrative as a way to sort of rectify a criminal past. Here, a perfect example of someone who does that, right? I lived that life, I told a bunch of lies, I lived deceitfully, and guess what? That will help me if I'm called to jury service. I found it fascinating, and again, this is an inductive study. I didn't know what these folks were going to tell me. But when they did, and it sort of played with prior research on voting and criminal desistance, it was quite eye-opening. Conclusions from study one, civic inclusion can foster identity transformations in big ways and in small ways. And it can prompt what I just explained, sort of desistance mechanisms. And finally, so there may be value in what other scholars have called strength-based or civic engagement forms of reentry, which is rather than seeing former offenders as a liability that you need to monitor and control, why not see them as folks who have assets and capabilities to be utilized and, for lack of a better word, exploited? Maine seemingly does that. They use former offenders with these capabilities and assets as jurors and exploit those assets and capabilities. So, study two, again, and I'm going to go through this sort of fast because I don't know where we are on time, but I feel like we're moving along pretty good here. 27 participants. This was with courtroom personnel. Same methods. I did a lot of this research at the same time over the course of about 3 years up here. What we found here, or what I found here, was that courtroom personnel, three themes emerged. They recognized the individuality of former offenders. They recognized that former offenders were similar to non-offenders. They just hadn't gotten caught, was what many of them said. And they questioned these categorical rationales that are in play in most other jurisdictions in the United States. They saw the value we just talked about in including convicted felons in the jury process, for the jury and for the former offenders. And what was fascinating in that study was that every judge I spoke to had a list of these factors that he or she would look to when assessing the fitness of a prospective felon juror. They were identical across judges. And I said, did you guys have a retreat and go out and discuss this at one point? And he said, I wish I could tell you we did, but it's just sort of being on the bench for X number of years, knowing what makes a good juror, knowing sort of the buzzwords, the buzz characteristics, we all sort of just came to this conclusion. And I'll talk a little bit about what those are. And finally, A minority of attorneys, prosecutors and defense attorneys, no judges really admitted to this or thought this, according to the data. They engaged in this form of othering, and they engaged in a form of othering with a very specific subpopulation, which are former offenders who had committed sexual offenses. A number of defense attorneys and prosecutors that I spoke to would be fine having a former offender on their jury, would seat them in a heartbeat. But when it came to someone with a sexual offense, it was a categorical move for cause, and if not, peremptory strike. So the sort of criminology of the other, while Maine seemingly defeats that in their jury system, still is alive with respect to one's population. Let me just go through, back up here. Let me just go through a couple of quotes because these are interesting. This is with respect to the first theme. One judge said, "I don't buy the every felon is a reflection of character because I've seen too many people convicted of felonies for things like selling a single Oxycontin pill or something else. It should be punished. Whether it should be a felony or not, I don't know. But I just don't buy that those people are of good character the day before they're convicted and bad character the day after." Another judge said this, "The majority approach is not individualized, the majority approach across the country. It's just felons have done something seriously wrong and therefore should be excluded automatically from an important task of citizenship. I think that's just too quick and too easy. In some instances, it's the right decision, but in many, many others, it's wrong in my years of experience." I don't think either of those rationales apply to that person. I don't think that they have a diminished character. And as far as showing sort of disdain for the government or sort of bias towards other criminals, I just don't see that being a factor, not one that wouldn't come to light during jury selection. Finally, a judge said, "Many offenders are just normal people who made a stupid decision or got involved in a stupid situation, and that's it. In the end of it, it doesn't make them bad people, it doesn't make them of bad character. I think that they can sit in judgment like anyone else." With respect to the second theme, sort of this finding value, one defense attorney said, "I definitely think that they might enlighten some of the other jurors. I just think that they might cause the other members of the jury to think a little bit more about what reasonable doubt is. And I think because they have been subjected to the process, I don't necessarily see that as a negative." A prosecutor said, "I see a benefit in bringing felons back into or allowing felons to serve on juries, and that is the sense of reintegration into society that we are, the person has been convicted, they've served their time, that's where society as a whole, the belief in second chances, and that telling them they can't serve on juries is a punishment that goes to the heart of what we do as citizens. It would be better to have them vested in the rights of citizenship than to have them feel as if they're alienated from those rights." Excuse me, that was a judge. A great quote here from a judge who had been on the bench for about 30 years, said this to me, "You don't want to be stigmatizing people or categorizing people in a situation where they wear the scarlet letter A forever. I mean, you know, Nathaniel Hawthorne is a graduate of Bowdoin, which is a school up here." Again, he thought I was this California kid. What we're really saying to people is we're not going to just put you in a box. We're going to actually take a look at you and make a decision on you, and not simply use some category you might be in as a result of events which transpired perhaps long beforehand. With regard to the third theme, these individualized fitness factors, I think all of you probably could come up with these factors on your own, right? They're logical factors. But what's interesting about it is I've been all over the country sort of talking about this, and here it was a very consistent message to prospective jurors with a felony conviction. These are the things, from every judge, these are the things we're going to look at. I weigh whether or not the felony conviction was in the county in which the jury is being selected. I weigh how long ago it was. I weigh the nature of the charges versus the charges at hand. I weigh the nonverbal conduct of the prospective juror in terms of how they related to their involvement with the criminal justice system. Whether or not it appeared to imply or connote a prejudice or animosity. I weigh whether or not the prosecutor in the case, or cases to be heard by the jury, was the same prosecutor that was involved in that particular felony. Those are the kinds of things I evaluate. One judge said this, "The rules of evidence permit impeachment with an implication that if you are a felon, a certain type of crime, you may be less credible than others. But even in the evidentiary setting, that simply is a factor for the fact finder's consideration. it is not dispositive, but it is a factor. And I think in the context of evaluating prospective jurors who are going to be sitting in a jury, I hope to inquire broadly enough that I can weigh that factor of history of a felony in the context of a much broader inquiry and then give it appropriate weight. So it was one piece of that person, and that was a whole person, right? And then these other factors that were consistent across people: how long ago was the felony? Was the felony the same as the one charged? Who was the prosecutor? What county are we in? And some spoke to what I would argue are non-relevant factors, which is how has this person's readjustment gone? Are they productive citizens? Do they have a job? Do they have a successful living situation? And when pressed, many of the judges there said, look, it's really about animosity towards the system and the idea that this prejudice might come through. And if they're having a hard time, that might be an indicator that there is still an animosity, there is still a bias, and that's not something we want to have on a jury. As far as this last theme, and quickly, I'll read you one quote. This was from a defense attorney who had been practicing for over 4 years, who said this: sex cases go to the character of the individual, and there's a conviction that shows that this person has a horrible character, and would likely, the consequences of being a sex offender are so dire or draconian that they have to be angry. You know, at the system, at the world, and they're sort of a pariah in all other respects. I don't think one can hold them out as being a neutral member of the community who can sit passively and listen to the facts and then not harbor any biases or prejudices. I would strongly suggest that that is a concern that the state should be trying to address with the court in getting that person struck. So that would be the type of charge I would look at and say that person shouldn't be here. One attorney also, who was fine with allowing convicted felons to serve, said a child abuser is someone that, in general terms, is somebody that I don't think has a proper thought process and has a marred character. So the idea that a felony conviction is telling of what kind of a juror you're going to be, it speaks right to the heart of your character, that still exists here in Maine, even with a very progressive sort of felon-juror inclusion policy, but only in a very small subset of cases. Conclusions of this study: look, Maine seemingly counters the idea of the criminology of the other, right? That we classify convicted felons that makes them outside of us. Some have argued it makes us feel better to do that. Here, we overcome that. There's a sort of chicken and the egg up here that I couldn't really get to, which is, are these policies the result of sort of a progressive court system for years, or are these policies pushing sort of the progressive attitudes I saw with respect to defeating the criminology of the other? And finally, folks in the court system seem to recognize worth for those who have been convicted of a felony. To a point, sexual offenders and sexual offenses, that master status still controlled for that subset of cases. So what do we know generally about felon-juror inclusion, exclusion? We know that the practice is not rooted in research or evidence. The practice is instead a vestige left over from ancient times, right? What we know from the empirical research that has been done is that convicted felons likely pose very little threat to the jury process in terms of how they deliberate and in terms of how they approach cases, right? Bias. And finally, that jurisdictions may benefit from inclusion. I think Maine is an apt example of that. Now, of course, Maine is a very limited, it's sort of a laboratory for these types of studies because it's the only place that does it. So I have no point of comparison. But from speaking with former offenders here, what the policy seems to suggest is that it does help them create a desistance narrative and overcome their past, and that, I mean, they look forward to serving. That was the general consensus. And looking forward to serving and being able to create that desistance narrative absolutely helps in the reintegration process. So I'm sorry, I know I spoke super fast. Presentation's over, there's my email, if anyone wants to call me up and tell me I did a horrible job. So, questions? Yes, sir.
I apologize if you mentioned this before, but I'm curious about your research methodology. Was all the felons that you talked with, were they all involved in jury trials themselves? Because there's a huge amount of cases being settled out of court or pleading guilty.
Right.
So I'm just curious if that had any impact on their perspectives.
So 7-0 in their own case.
Well, I guess if they're to be a jury member
Yeah.
and they didn't have a jury trial, because I admit my first instinct was similar to the common view that they would be prejudiced, like they wouldn't want to. And then I was thinking, well, did they have a jury trial themselves?
Interesting. Out of the, in that study, I think I had 76 and 1932. And I have the data. I actually didn't put that in the pit. That's an interesting question. I have it was about half had gone through, had a jury trial, and about half had taken deals. Yeah. So, which was way high. I thought I'd have 7 or 8 maybe out of 32 at the most who had been through a jury trial, but about half had been through. Now, most of these folks were had multiple cases, so in that respect, you got sort of more bites at the apple, and I don't know that. So they had more chances of having a jury trial. So about half, though, at one point in their life, sat as a defendant in a jury trial. Yeah. Yes, ma'am.
Do you feel like there's any difference in capability to serve depending on how long you've been out of the system? I mean, do you feel like your service on the jury panel would be the same whether you were 5 months out of probation or 10 years?
So interesting you asked that. So that first study I showed, the 2014 study, what we did was we gave 240 convicted felons a bias test, right? And it's not an implicit, you've heard about implicit biases. This is like an explicit bias test, right? And it's a sort of the accepted bias test in the field of jury research, and I gave them 4 different ones, and they're all different questions arranged differently, and the validity of it is high. Doesn't predict much of the variability in verdicts, it's just the nature of the beast, but it's the highest, it predicts enough variability that it's the highest ranked scale in the business. And what we found there was that it was a sort of normal distribution of, so about 1/3 of those polled out of the 240 convicted felons were either neutral on these scales, perfectly neutral, or pro-prosecution, right? The other 2/3 were pro-defense. To speak directly to your question, the way that I sampled convicted felons for that study was I intentionally biased the study towards a pro-defense bias, in that every single person who took part was within 30 days of being released from prison. In California, we have these things called parole community team meetings, PACT meetings, where convicted felons are required to go to these meetings to be exposed to the local resources to help them reintegrate. And so I polled at those PACT meetings, which they all had to go within 30 days of release, thinking that if I found that effect, I could then explain it as saying, oh, well, they're not that far removed from prison. But even that effect didn't happen. So.
Is there anything special about the one-year process in Maine compared to other states, or anything that stood out to you from your interviews with prosecutors or attorneys?
No, I mean, every defense attorney argued that it was too truncated, that they wanted more ability to ask more questions and do a thorough examination. They all said, well, like you do in California, judges ask questions. They talked about the questionnaires in certain cases. The felony conviction is typically on a questionnaire in most of the counties that I was in. Their general impression of it was that it could be more reaching, but that it was adequate in terms of felon jurors, that they got to sort of the root of what they needed to get to with respect to people with a criminal conviction. In other respects, they thought that it was a little bit superficial.
In either of your studies in Maine, did anybody bring up how race does play a fact into having that greater chance of having a felony, and like how this might, like you're talking about the study in the South, like how it does affect jury trials, especially in death penalty. Did anybody bring this up in your questions, or you had a question about that in your interviews?
Well, they did not. And so your jury population is about 95% white or something out here. So that wasn't something that came up here. It came up in that first study I did with respect to bias. A couple things drove that bias, made it less likely that someone would have a pro-defense bias. Repeat offenders tended to have they tended to land on the pro-defense side. First-time offenders were more of our pro-prosecution neutral folks. And also race drove that. So the African-American, Latino population in California are more likely to be convicted of a felony, and so that came through. Most of our population was Latino or African-American. But in terms of up here, no, that wasn't an issue that came up.
So I guess I'm wondering, did you look at like some results from actual trials, like whether having a convicted felon sort of skewed for defense, like in results versus the mean of places where there was no felons on?
I didn't look at verdicts, so, yeah, I'm sort of ashamed to say this, but so you see jury consultants all the time, right? So the bias score, the bias scale that I used in that first study, and I'm going to answer this in sort of a roundabout way, explains 4% of the variability in verdict preference. 4%. So that's what's sort of scientifically explainable. So that's not a lot, right? In terms of demographic factors and what really, there's studies all over the map when it comes to jury research. They do not explain verdict preference. I did not look at verdict preference on juries that had convicted felons, only because, to be frank, the NSF gave me a little bit of money, and that would have required sitting for a long time. So, you have to hit the right jury, and jury commissioners, which I asked, were willing to sort of give me a call when they heard that there was a convicted felon in the pool. And prosecutors weren't willing to, because prosecutors up here run the list. So when they get their panel, they run the list in their own county database to see who hits for a felony conviction or misdemeanor, and then they do their jury selection accordingly. But no, I did not look at verdict preference with respect to that. And in our deliberation study, where we put non-felons and felons in the same room and had them deliberate over a mock trial, it was only 21. It was only 21 juries, and it was about 2/3 acquit, 1/3 convict, and it had nothing to do with whether. So that was more of a qualitative study. How did deliberations look? How were the interactions? There weren't the numbers to do a nested design, juror within jury, to have it sort of be any meaningful results with respect to verdict preference. You'd need to run 150, 200 juries to get that second layer, to do that nested design. Anything else? Well, thank you again for letting me come up here. This is great, and I appreciate it. So, any questions?